So, module 2 talks about the liability for the wrong committed. So, whenever there is a liability in the tort, which is the most crucial element, it delineates the responsibility that one party holds for causing harm or injury to the other party. So, we will explore the liabilities for the wrong committed in this module. So, very first sub part or the chapter under module 2 is strict liability, absolute liability, no fault liability, and some exceptions to this. So, what is a strict liability? We spoke about it last time also in a bits and pieces. So, we cover it fully in this particular module. So, by definition, under strict liability, a party is held to be accountable for damages irrespective of fault or negligence. So, either fault or negligence, either of the way, the party is accounted. It is primarily used in cases involving inherently hazardous activities or defective products also. So there is a strict liability. So whether a doctor does a surgery by mistake or does a negligence by leaving a towel, we talked about the example last time. So the very first case law we can talk about the strict liability under strict liability is Rylands versus Fletcher, very famous case. Rylands, Rylands versus Fletcher, 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 cases of 1868. Now, this case law established the doctrine where liability is imposed on the landowner who conducted potentially dangerous activities on the land. The Fletcher's land, in this case, was flooded by water escaping from Rylands reservoir. So the judgment said the court had Ryland strictly liable for the damages as the retention of water was a non-natural use of land. So lands are not normally used to store water. So he went ahead and he stored water, which was a non-natural use of the land, and that is why the court put the strict liability on in this case. Second case law is Cambridge Water Company versus Eastern Counties Leather PLC. I don't think spelling is required for the first part. So Cambridge Water Company versus Eastern Counties Leather PLC. This is matter of 1994. So this case law is particularly talking about one aspect of strict liability where foreseeability is one of the elements of strict liability. You should foresee what damages you could make to others by your act or your negligence. So the contamination from chemicals used in a factory, the factory, leather factory, it seeped into the soil and affected the water supply. It went ahead and polluted the water supply. So there was strict liability was not applied because the damage was not foreseeable, hence underscoring the limits of strict liability. So foreseeability is a very important element. In this case, what happened? He opened a leather company. He followed all the legal norms. He, under those restrictions and controls, he did everything. But unfortunately, the chemicals seeped into the soil for which there was no liability or accountability of the other party, the leather company, because they were following every regulation to safeguard the environment. But probably that was not part of the environmental law and rule and the regulation at that point of time. about putting some barriers in between. So it was not his fault that he has not followed anything and did something wrong. He was just running a business with as per the rules and regulations and as per the norms. He could not foresee that something as dangerous could happen, that from his factory down under hundreds of feet soil, the chemical will seep in and it will pollute the water. So, because it was unforeseen, it unforeseeable, the strict liability is was not applicable. So, although strict liability is something which is because of a fault or a negligence, but if it is not legally considered to be unforeseeable, in that case, the strict liability is not applicable. So, strict liability. Then now we talk about absolute liability. A doctrine tailored primarily for the absolute liability is a doctrine tailored primarily for hazardous industries operations, where the liable party has no defense available against claims for harm caused. So this is a doctrine tailored primarily for hazardous industrial operations, where the liable parties has no defense available against claims for non for harm caused, because this is a hazardous industry. They are part of that hazardous industry by knowing, and then they have a liability. So very famous, we discussed earlier also, is MC Mehta versus Union of India 1987. The Indian judiciary introduced stringent liability norms without exceptions for hazardous activities. Any hazardous chemical or such industry which is working. So an industrial gas leak harmed many residents. Industries were held liable for mishap irrespective of precautions due to the inherent risk. So they had an absolute liability in this case to ensure the things run fine, and even if in cost, irrespective of precaution, as they themselves started a business which was in hazardous in nature. So in any case, in spite of precaution, because of the inherent risk in the business itself, it was uh, considered as an absolute uh, liability on part of the company. Similarly, the famous one also is Union Carbide Corporation versus Union of India, which is very well known as Bhopal gas tragedy. So Union Carbide Corporation versus Union of India, which is called Bhopal gas tragedy. It is a matter of 1989. It is a landmark decision which went for multiple years, where absolute liability was discussed in the context of industrial disasters. So the chemical was leaked. It's a very well known to most of us, from a Union Carbide plant, led to thousands of fatalities in India. It was such a dangerous gas. Wherever it went, the people died in sleep. So the principle of absolute liability was invoked to ensure compensation without defense based on lack of negligence. No defense is even allowed, because you already started a business which was considered risk. I mean, there could be a higher level of argument in duality, saying the government itself has approved such an industry, but then it is not applicable in terms of the legalities. So if you start a hazardous company, any kind of hazardous business, it's a by inherent, it's an inherent risk which is there, and you are absolutely liable for any of the damages caused because of that. One more example I'll quote. It's from the recent years. It is LG Polymers India Private Limited. LG Polymers India Private Limited matter of 2020, which is also known as Vizag gas leakage. This was the situation where the fact of the matter is styrene gas leaked from the chemical plant, and that caused a lot of injuries and death also. And the National Gas NGT, the National Green Tribunal, confirmed the liability of the industry under absolute liability, and which is then caused in compensation order to the people who were either injured or dead. So this is similar to Bhopal gas tragedy. This is Vizag gas leak tragedy. Now let's come to the third one, which is called as no fault liability. Strict liability, where because of your any fault or your negligence, something happens. Already one exception is there if it was unforeseeable. then it is not applicable. Absolute is by nature of inherent nature of the business. The liability is absolutely there. And now next one is no fault liability. So this is a liability where providing fault or negligence is unnecessary. So we are proving the fault or negligence is unnecessary, often applied in specific contexts such as motor accident claims or workers' compensation cases in factory accidents. So this liability is where proving a fault or negligence is unnecessary. Example, a no-fault car insurance. Insured parties receive compensation from their own insurances after a car accident, regardless of who was at the fault. So when you go and do an accident, the insurance is invoked and you recover the charges from your insurance policy, but it is only the damages and the legibility of the damages is checked. Nothing, regardless of whether it's your fault, it was somebody else's fault. Example two, workers' compensation. So an employee injured on the job receive benefits without having to prove the employer's negligence. So if an employee is injured, no fault liability is there, and without even need to prove the fault of the employer, any negligence, the worker is compensated. There are exceptions to no fault liability or to either of the liabilities. It is act of God, which is a natural unforeseen event, or consent, which we spoke last time, and where the plaintiff consents to the risk liability may be diminished or negated. So these are the two exceptions. So strict liability is a liability because of fault and negligence. Exception is unforeseeability. Absolute liability by nature of the hazardous business. No fault liability where no need to prove any fault or negligence, but the compensation is provided, and exceptions are act of God and consent in all these scenarios. Come to the next part, which is principle of vicarious liability, its nature, scope, jurisdiction, etc. Now, vicarious liability holds an employer or principal liable for the wrongful act committed by an employee or agent, provided these acts occur within the scope of employment or agency. So it holds an employer or any principal liable for the wrongful act committed by the servant, the employee or the agent. So either the person who is on his salary is doing his enact during his actions within the scope of his or her employment, or the agent while running his agency and continuing with the activities which are required to be part of the job to run that agency. So within the scope of running that agency, in those cases, the employer and or the principal is liable for the wrongful act committed by such an employee or an agency. Case law 1. Century Insurance Company Limited. Century Insurance Company Limited versus Northern Ireland Transport Board. Northern Ireland Transport Board, matter of 1942. This was a matter which emphasized the employer's liability for Employees Act during work. Facts. So the employee caused an explosion while refueling. The employer was liable as the act was executed during employment duties, and for all the compensation, the employer was having a vicarious liability. So the employee caused an explosion while refueling, which was part of his job, and the employer was liable. Case 2, Beasley versus Curry. BAZLEY Beasley versus Curry of 1999. This explored the employer's liability for employee misconduct even outside professional duties. Now, institution held accountable for employees' abuse of position. The employee did some abuse of position in this matter. The court ruled the liability due to the environment created by the employer that entitled the abuse. So in spite of not being directly in the uh, four walls or the scope of the employment, what he was doing, that particular employee, court still rule liability to the due to the environment created by the employer, which allowed that person to use his abuse of power, and there was no checks and control, no kind of training, no kind of such liability called out to the employee, and in that case, the kind of employer's environment created has enabled the employee to do such kind of abuse of power, and that is why the employer was held liable under the vicarious liability. So this is the basically the definition and the case laws related to the definition where the vicarious liability is holding the employer or principal accountable for the wrong done by the employee or agent in within the scope of their actions done in furtherance of the scope of their employment or agency. Now, what are the justifications of certain things? For example, the risk allocation. So, employer often absorbs the cost resulting from an employee's action as they have control and the ability to supervise. So, basically, the risk allocation, why in vicarious liabilities it is done to the employee is the employer to the employers, sorry, not employee, employers, because employers often absorb the cost which is resulting from an employee's action as they have control and ability to supervise that. They understand that risk can happen and that is part of their business and to supervise and ensure this does not happen. So end of the day, this is part of their own establishment and this risk allocation is that is why to the employer. Encourage entities to maintain prudent oversight and purposefully mitigate risk stemming from the employees. It is the role of the employer that they bring an incentive for the control. So it is a basic rule for any risk or any kind of control mishap. The employer has to encourage as a duty to the other entities or employees working with them to have a prudent oversight, be careful, and purposefully mitigate the risk by doing so. So that is why the employer is again hold liable. Then financial capacity. So the employers typical possess greater financial capacity to provide remedies for any tortious act done from the employee, and that is also something which is already covered in financial terms as the risk items in the financials. So they already have calculated those risks and damages which might occur up to what extent, and for that they already have the financial preparation. They are in a firm financial position based on that, and in some cases they might also have a third party uh, taking care of those liability as well. For example, the various insurances related to their operations. So let's take off a couple of more examples of vicarious liability to understand it better. For example, if a delivery driver causes an accident while making deliveries, the company can be held vicarious liable for the driver's careless action because they were acting in course of their employment at the time of the accident. And as we understood few minutes back, the risk allocation, the incentive for control to be established, and the financial capacity is with the employer. And that is why, for the in this such kind of scenarios, the vicarious liability will be on the delivery driver's company. Example two. For example, a school is held liable when a teacher knowingly mistreats a student. Since the teacher is an employee acting within the scope of the assigned duties in the school must address the resulting claims for the damages, and school was responsible to manage that as well. So that is why it is considered that the it's employees liability in case of sorry employers liability in case of employees or agents mistake wrongdoings. So this talks about the nature and the scope and the various justifications why the liability falls on the employer and not on the employee in case of vicarious liability, where they are acting in furtherance of their employment or running the agency. Next point is doctrine of sovereign immunity. We touched upon it in one of the previous sessions, the doctrine of sovereign immunity. Now we take it formally here. So, sovereign immunity refers to the legal doctrine that protect any government and its entities from being sued without its consent. The rationale behind this doctrine is rooted in the principle that the state cannot be a defendant in its own courts. So, this refers to a legal doctrine protects the government and its entities. Now, take an example to understand it better. A citizen cannot sue the government for damages resulting from a road repair job that was negligently managed, as the government has sovereign immunity from suits for such claims unless there is a waiver of that immunity. A public school district cannot be sued for inadequate educational resources unless state law expressly provides for such claims. So this is historically coming from the English common laws, which holds that the sovereign cannot commit a legal wrong, and it is exempt from lawsuits. This principle aims to prevent interference with government functions. But for such examples, there had been exceptional case laws where the state agency or the one of the component of the or one of the employees of the state government or a department of the state government have been liable in due course of actions. But in general, the sovereign immunity, the doctrine is which protects the government. Case law is Bhopal gas tragedy case again. It exhibited a concern regarding the sovereign immunity when victims sought redress against government entities for negligence. It was a government entity during the gas leak tragedy. The court ruled on the limitations imposed by the sovereign immunity for public bodies, but allowed for relief under specific statutory provisions. So that is why there are cases which are against the state also, but then it's a discretion of the court to bring in the right justification to ensure such limitations of immunity for the public bodies and under specific statutory provisions. Various strict laws regarding management, hazardous business, etc., etc. So the very important step why sovereign immunity exists is, first of all, sovereign immunity protects the government authorities. That is why the government, all the governments put it from lawsuits that could impact their operational function. And it brings in the thought behind having it is it holds a stable legal environment by limiting frivolous lawsuits suits against the state, helping ensure efficient governance. So this is a little bit of a gray area in between, where although there is a doctrine of sovereign immunity for damages, etc., but then under statutory laws, a punishment can happen and such a case could be filed. So you can definitely not get a tort for suing the damages for a road repair job and you got damaged, but then you could criminally sue the road department, and the engineer or the person who is directly responsible might be punished because of that. And so that is something which is doctrine of sovereign immunity. Let's move to interesting topic, joint tort feasors and joint and several liability. Now, what is a joint tort feasor? So, when two or more parties commit a tort together, that is why the name is joint tort feasors. So, when two or more parties commit a tort together, they are considered joint tort feasors and can be held liable collectively. Then we have joint and several liabilities. So, this principle allows a plaintiff to pursue all liable parties together or individually for the total damages. This means that any one tort, whatever tort has happened, the tortfeasor can be held responsible for the entire damage award regardless of their individual proportion of fault. So either way, the liability could be put on the switch on the light. To put on the liability the both of the joint tortfeasors. So it's a joint or several liability depending upon that. For example, in a fight in a bar or a restaurant, two individuals jointly assault another person. So A, B come and they assault C. Now victim can sue either one or both for full damages resulting from the assault. It's depending upon the victim. So the victim can either sue either one A or he can sue jointly A and B together for the damages recovery from the assault. So if he goes ahead and if he the two joint uh, tortfeasors here is A and B, and if he takes a liability, the damages from A and B both together, it's a joint liability. If he wants to sue only A, he can sue A only. This is a several liability. Example 2. A group of manufacturers produce a defective product causing harm. So, for example, certain machine or certain equipment was made which was produced together by multiple producers. They affect consumers, the affected consumer can sue any one of the manufacturer for the total damage, and it is up to him to seek contribution from the others. So, in case of the joint liability on A and B in the previous case, although if it is not a joint liability and the C wants to go for a claim of liability with only A, then internally if they want to do a contribution, that is their own business. But it is completely on discretion of C here that he wants to have put A and B both for liability or only A. Whose against he wants to put. Case law example, Anderson versus E dot I dot, so it's short term. Anderson versus E dot I dot DuPont. DuPont, P-O-N-T, separate, different word. Now, DuPont, D-E. Then next word is Nemors, N-E-M-O-U-R-S, N-E-M-O-U-R-S, and company, I-N-C. So this is Anderson versus E.I. DuPont, Nemors, and company, I-N-C. Several companies were responsible for pollution that affected a community's water supply. The court held that each company could be held jointly and severally liable for the damages caused. So even if the specific contribution of each was unclear, that how much which has polluted, it could be joint or a several liability. So the court awarded compensation to the affected residents, allowing them to recover from one or more of the responsible companies, regardless of their individual liability share or contribution in the pollution. Next case example is R versus McDonald. R versus McDonald. I don't think McDonald spelling is needed to be explained. So R versus McDonald, 1993. So multiple defendants were involved in an accident that caused injury to a plaintiff. And this is matter of 1993. Huh? So the court ruled that all the parties could be jointly liable for the entirety of the damages, illustrating the principle of joint tortfeasors in action. And the judgment which came finally that the plaintiff could pursue compensation from any of the parties or all the parties, affirming that applicability of joint and several liability. So under these 4 points, what we understood today is in module 2, strict absolute and no fault liability, which addresses the various standards of liability based on the nature of the act. So strict, absolute, and no fault liability is based on nature of the act, distinguishing the level of the fault and defenses applicable. Then we talked about vicarious liability, which is employer's responsibility for employees' action, and it promotes accountability and clarifying liability across employer-employee dynamic. Then we discussed about sovereign immunity, which protects the governmental entities from litigation, balancing the state function with accountability and citizens' right. While the last one we saw in module 2 was the joint tortfeasors and the liability, either joint or several liability, which explained the multiple parties can share responsibility for tort or could be accountable for the tort, providing avenues to the victim, option to the victim to seek a full compensation regardless of individual culpability from one of the individuals or parties or all of them together. So this concluded module 2. 3 we had done that day, the general defenses. Now we move to module 4. And 4 and 5 are torts against person and the reputation. So let's talk about tort against person. So it refers to a civil wrong that can cause harm or injury to individuals through direct actions, emotional distress, or through malicious legal maneuvers. So either of the three is covered in tort against persons. Understanding that these torts are crucial and this forms for the basis of personal injury claims and legal accountability in the society. So let's see. The very first topic is assault, battery, and mayhem. So let's understand first the difference between all three of them. We'll see the examples after that. So assault. Assault refers to intentional act of instilling fear of imminent harmful or offensive contact in another person. It does not require actual physical harm. Merely the perception of the threat itself is okay to consider it an assault. For example, a person raises a fist and threatens to hit somebody, that I'm going to hit you on your face. That immediate threat, which is caused in the mind of the person and which the victim perceived it as genuine, and it constituted the element of sudden fear in the person, the victim. It constitutes assault even if no physical contact occurs. So even if he does not hits really with the fist, but that fear which was instilled, that itself is called an assault. Battery involves the unlawful and intentional use of force against another person, resulting in harmful or offensive conduct. Unlike assault, battery requires that the contact actually occurs. So for a battery, a contact has to occur with the body. And this is unlawful in nature and intentionally it was used by force against another person resulting in a harmful and offensive contact. The contact has happened. So example of battery is if a person throws a drink on another during an argument, that act of throwing the drink qualifies as battery since it involves offensive contact has happened. Mayhem is a more severe form of battery that involves the intentional infliction of serious injury on another resulted in permanent injury or the disfigurement of a person where somebody comes and hits with a metal rod or something. So assault, battery and mayhem, if we remember, this is an increasing order of fear and injury. Assault only can happen when it is even tried and not actually executed. Battery is an in unlawful intentional use of force where a physical contact happens. But mayhem is a more severe form where it involves a heavy force against the other person, which causes infliction of serious injuries. Maybe sometimes permanent injury or disfigurement, all those things can happen. Now, let's take example of few case laws. So, R versus Ireland, 1997. So, in this case, a man received through his contact a phone number of a woman. And then he started to make several silent phone calls to the woman, causing her fear. He didn't utter a word, but every time he will call silently and instill fear in the minds of that lady. So the court recognized that the threat or actions causing apprehensions constitute assault. So even without direct physical contact, there was a assault which happened in this case, and the ruling affirmed that the psychological harm could form the basis for an assault claim. Next case law, Lycett versus H.C. Hyman's Company, 1949. So Lycett, L-E-I-C-H-T, L-E-I-C-H-T, Lycett versus H.C. Hyman, H-E-I-M-A-N-N, Hyman Company, 1949. So a worker was injured intentionally while his supervisor tossing materials at him. So he started to toss heavy materials on the worker due to some dispute, and he injured the worker. The court found that this constitute battery because the supervisor's action was intentional and it did cause harm. It wasn't even necessary. So compensation was awarded. In the same case, if the same uh, uh, person, if he might have uh, took out a rod or a hockey stick and would have done the same thing to one or more employees, it could have been again against mayhem. So this is assault, battery, and mayhem. Now, tort against person could also be only the emotional distress as well. So any emotional distress also is covered under the tort against the person, and there is a resolution under tort for the same. So when we talk about the emotional distress which is causing it to somebody, what we're talking about is intentional infliction of emotional distress, which is called as IIED in short. So it is called intentional infliction of emotional distress, IIED. This tort occurs when one party extreme and outrageous conduct causes several severe emotional distress to another person. So it requires that the defendant, his action or her action was intentional or reckless, and that the distress partook of a severe nature. It was of very severe nature. Hmm. For example, Saas Bahu. Hmm. So, example one, a person spreads false rumors about another person and causing the later significant emotional trauma and anxiety. Not everybody can take emotions that strongly. The impacted individual may claim damages for the emotional distress caused by the malicious action of the other person because it caused huge emotional distress to the person. Other example could be a company which threatened to disclose sensitive personal information to intimidate an employee, resulting in severe emotional injury to the employee, is also part of causing emotional distress. So the companies at times ask people to disclose their personal information in course of getting a employment with them. It might be related to their body, their family, their marital life, their abilities, or even their financial position. For example, all the international banks, when you work or invest in companies, they ask for all your financial records as well. So if somebody says a company goes ahead and tries to force somebody that you do this, otherwise I'll disclose your sensitive information, this is a causing emotional distress, and it comes under intentional infliction of emotional distress, IIED, and this is something which is could be brought under the Tortious Act. So let's take the first case law, Taylor versus Vallelunga. So Taylor, Taylor versus Vallelunga. V for victory. So VALLELUNGA. VALLELUNGA, matter of 1965. A woman witnessed her father being beaten, leading to serious emotional distress. So the court found that the witnessing extreme violence inflicted on the loved one can also cause IIED. And this is where there was not a single crime or action. Whatever the beating was happening, it was nothing actually on her, but it was on a loved one. And this is why the judgment came back and compensated her for the emotional injuries resulting from the conduct of the person towards her father. Another example is Harris versus Forklift Systems Inc. HARRIS, Harris versus Forklift, FORKLIFT, one word, Systems Inc., matter of 1993. Now, an employee faced abusive conduct and derogatory comments at the workplace. So he was always getting abusive conduct from his people around working him, his seniors, his workers, and very derogatory remarks against himself at the workplace. So the court recognized the conditions under which emotional distress could be actionable and emphasized that the importance of a assessment of a hostile workplace. So the employee was awarded a compensation for the damages for the emotional distress caused by the workplace harassment. So, in a nutshell, the emotional distress which is caused because of intentional infliction of emotional distress, IED, is something which could be claimed under tort, and these are the few examples which we discussed right now. Point 3 talks about another kind of tort against persons which can happen is malicious prosecution and abuse of legal proceedings or false imprisonment. So this is legal in nature. So first one was kind of physical harm, second one is emotional harm, third is legal harm. So this is in category of legal harm. Now malicious prosecution means what? This is taught when one party pursues a legal action against another without probable cause and with malicious intent, resulting in injury to the defendant. So the tort has happened and the legal action has been initiated against the victim here without any probable cause. There was nothing which was even expected or something which was not very clearly quoted out what is expected, but with a very malicious intent resulted into the injury of the defendant. What injury of the defendant will happen? Again, it will be IAED only. But this was done in legal means. Abuse of legal proceeding is another way when a legal process is misused, causing harm to another party. So this can include frivolous lawsuits or using legal mechanism to harass or intimidate something. So this is also which will cause either IID or some kind of financial or physical loss or both of them. Then false imprisonment is also one of the elements where the unlawfully somebody is restrained about and is freedom of movement, etc., is taken away without consent or for legal jurisdiction justification. So malicious prosecution initiated by one party against another or multiple parties against multiple parties or multiple parties against single party. Abuse of a legal proceeding where the whatever it is process was supposed to be, it is used instead of using, it is misused. And false imprisonment. For example, certain CRPC provisions allow a police officer to arrest somebody when he or she feels there is a commission or going to be commission of a cognizable offense, which is a good legal process, which is given in the hands of the police to ensure if there is something going to happen and the police officer is nearby and he or she is a witness to that, they can come and stop the person or the persons to commit the crime. But the misuse what happen, which could happen, is there is some out of some malicious intent or in abuse of the power for some reasons where some benefits were sought from the victim and which is not fulfilled, the police officer may come back and use his power of arresting without any warrant and in witness of any probable cognizable offense. May I just arrest you and put you behind the bars, mentioning he witnessed something which might have which might be a cognizable offense which can happen. So this is a example of abuse of legal proceedings. So let's take examples, some more example. So an employer files a criminal case against an employee to retaliate for a personal dispute. There was a personal dispute and you filed a legal dispute as an employer. So these are baseless and the charges were eventually dropped, but the abuse has happened. It's a legal abuse. A store employee detains a customer without probable cause, suspecting them of shoplifting and refuses to allow them to leave while nothing of such sort has happened. Again, a misuse. For example, a woman going ahead and filing a harassment matter or a maintenance matter against her husband and in-laws. When the final judgment comes, it was found that it was done all under malicious intention. So that also comes under this category of fraud. So let's take case example of Clean versus Harris, Klein, 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 Klein versus Harris, 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 1888. The plaintiff was subjected to a criminal lawsuit instigated by the defendant without causing to produce any sufficient evidence. The charges were ultimately dismissed. And the legal reasoning what the court provided was the defendant acted within the malice or without probable cause in bringing about um, the plaintiff acted with a malice and to without any probable reason bringing about the trying to bring the prosecution, and the court ruled in favor of the person awarding him damage for this malicious activity. Next case law is Fagan, Fagan, Fagan versus Metropolitan Police Commissioner, 1969. Fagan versus Metropolitan Police Commissioner, 1969, Fagan and Fagan. So the plaintiff was wrongfully arrested by police, who mistakenly believed he was involved in a crime. So he was confined without proper legal justification. The court examined the nature of the arrest and the failure to provide legal grounds for the confinement, and then there was a identity which was misunderstood by the police or was not verified by the police. So the verification was not done. So the court found that the police has acted without proper justification and without verification, determining that the plaintiff's right, were not respected. And in violation of that, plaintiff's rights, when violated, the because of this false imprisonment, he was allowed a compensation against the Metropolitan Police Commissioner. So, assault, battery, mayhem, physical nature, emotional distress, of course, mental in nature. Three, malicious prosecution, abuse of legal proceeding, false imprisonment, etc. Legal uh, torts against the person. Now, deceit and conspiracy is also an kind of crime which can happen against the person. Sorry, torts which can happen against the person. It's called deceit and conspiracy. So, deceit, by word, meaning of the word is a false representation made knowingly or recklessly, leading to loss or damage to another party. So, if you want to do a false representation and knowingly or recklessly, either way, it is okay until the point of time it is not causing a loss or damage to another party. So, it is primarily concerned with fraudulent conduct that misleads other. Fake police officer, fake CBI team. Conspiracy, on the other hand, I'm sure you know the meaning of the conspiracy, refers to an agreement between two or more parties to commit an unlawful act against another. So, two or more other parties, when they um, two or more parties, when they conspire under an agreement to commit an unlawful act against another, which resulted into a harm. So, why resulted into harm is important? Because until there is no harm, there is no tort. So, the cause of the tort will not come. Even the cause of the crime will not happen, actually. So, until and unless this is not resulting in harm, so once they two or other people conspire to commit something unlawful, again it has to be unlawful against somebody resulting in harm. For example, if two of you plan a birthday party of your friend and you suddenly bring in a cake, and while bringing the cake, Bharat slips and falls on the face of the other person for whom we have brought the cake, and it damages his some part of skin, some damages happen, then it is not a conspiracy because it is not cause for the intent of harm. So only a negative planning which is done is under considered conspiracy, and then definitely if it's a negative plan, it is something which will harm somebody. So in conspirator, each conspirator may be held liable for the actions taken in furtherance of the conspiracy, regardless of their direct involvement. So if there was a conspiracy where I bring in um, um, some plan against somebody together with one of my partner, and we planned that we'll put a conspiracy to damage his reputation or to damage his make a physical harm to him. And in that course, I was directly involved. The other person was supporting me. It does not matter. The liability of each of the parties is conducted and is considered in the conspiracy. So let's take an example of deceit. A business, sorry, represents the quality of its product to induce a customer to make a purchase. So very good products are very nice, quality tested, blah blah blah. And while the person purchases it, it causes a financial loss because of the damages by using that product and the purchasing of the machine or the product itself when the product fails to meet the advised standards. What was the advertised standards? It fails to meet. And conspiracy could be many, but let's take about one example. Two individuals, they agreed to spread a false statement about a rival business in order to harm its reputation, and drive the customers away. So their coordinated efforts result in significant financial damages to the other business. So that is also coming under conspiracy, and it comes under deceit and conspiracy. So case law, Derry versus Peak, Derry, Derry versus Peak, Peek, 1889. So the plaintiff claimed a company's directors made false representation about their tramway company, leading him to invest in it. So there was false representation made about a tram company. Tram, you know. So we have tram in Kolkata. It's a kind of a small bus which runs on a railway track, and multiple bogies are connected like train. So a tramway company he made representation about, which was a false representation, and hearing that, the plaintiff made some investment in it. The court ruled that one could only claim deceit if it could be proven that the representation was made knowingly or recklessly. And the court ruled against because the directors had a genuine belief in the statement's truth and highlighting the need for intent in claim of deceit. So it was intentionally made. It wasn't happen so that he walked across the company and believed that it's a tramway company and went ahead and did a investment in the company. No, he was made to believe that this is a tramway company which they're representing, and so are the benefits and the factors, and then he decided to make an investment. So that is why the person who invested won the case against the company which made a false representation under deceit. So this was an example of deceit. It could also be an example of conspiracy if there were more than two or three persons did the same thing. So one similar deceit matter we have won in Pune Khadki court also, where similarly one company made a website representation. It's a good example of being an EV charging company. They manufacturing EV chargers. And one other person who believed in the company went ahead and invested in the company and ordered about 14 different machines, which was never delivered. And over time, they came to know that they were not even a manufacturer. They don't even own a company. They were just having a website and few LinkedIn posts and LinkedIn um, uh, profiles, nothing more than that. So this was also a perfect case of deceit where they made to believe the other person to invest in the company. Next case example is Kerr versus Baird. So Kerr, Kerr versus Baird, 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 1881. So several businessmen conspired to ma- maliciously undermine a competitor's business, leading to economic loss to the for the competitor. So they made such a conspiracy that the other company lost considerably. So the court found that the defendants were liable for conspiracy as the agreement to engage in a harmful action constituted a wrongful act collectively against the plaintiff. So the court awarded damages, emphasizing accountability in conspiratorial action that resulted in economic harm, and it was decided under the rule of conspiracy. So deceit and conspiracy is again one kind of crime. Then particular defenses available in each of these types. So each of these types, what could be the defense? So actually this is something related to module 3 also what we discussed, but let's talk about it. For example, defense for assault, battery, mayhem, malicious prosecution, etc., could be one is could be consent. So in case of assault or battery if the victim consented to the act, knowingly participating in a contact sport. For example, the defendant may assert this as a defense. If I say you have made my eyes blue and black by punching on me and I consented to a boxing fight with you, where you are a boxer and I'm not, I give a consent. Self-defense. The individuals may claim self-defense if they acted to protect themselves from the imminent harm, and this defense is applicable in assault and battery cases. The person can take a defense of doing it under the pretext of self-defense or defense of property. We discussed earlier also. This is also one of the very important defense where similar as a defense to the property, you can justify you have done it. Example which I mentioned last time, where somebody is trespassing somebody's property and he picked up the person and picks up the person and throws him out of his property, which in which the person gets some damages. That damage is defense of property, and if that could be called as a mayhem or battery or assault, no, it cannot be. That's a defense for the other person because the other person had no right to visit the property without any permission or knowledge of the person. There are some defenses available for emotional distresses as well, specific to emotional distresses. For example, truth. So in defamation case leading to emotional distress claim, proving that the truth of the statement may serve as a valid defense. That what I said was truth, which has caused a emotional distress to the person, and that's what is the defense I am putting forward, and I have no responsibility if somebody gets an emotional distress just because I quote a fact in front of that person. Second thing, for emotional distress, the second defense could be absence of intent. So that you have the person has to demonstrate that the actions causing the distress were not intentional or reckless, can mitigate the liability. So it was not intentional. For example, the recent uh, case where the one stand-up comedian talked about one prominent leader about certain things he or she has done in the past. It caused a lot of noise from the side of the politicians saying it's a defamation, it's causing me mental distress. This is not right. But when the Supreme Court took a suo motu cognizance of it, they say we are as countries with 75%, 75 years of independence now, and we cannot take with a pinch of salt a small comic intent and make so much of noise against people against their own fundamental rights to do so. So this is one of the example where there was an absence of intent. The purpose was something else, but it was considered as a tort against the person. So let's take some case law examples for defenses. For example, for consent in assault and battery. Case law is Alder versus London Electricity Board. Alder, ALDER versus London Electricity Board, 1970. This case, the defense of the consent was that the plaintiff participated in an activity that involved inherent risk leading to an injury. So it was basically the participant who took a risk himself by even, see, consent could be of two types, right? Consent could be, 1 minute. So consent could be of two types. Consent could be express also or implied also, right? Just 1 minute, I'm getting a call. So if that kind of uh, risk was taken willfully, then this was a defense, and this is one example. Now, example for self-defense in battery. So R versus Palmer again. R versus Palmer, PLMER, Palmer 1971. So the court ruled in this case that the defendant acting in self-defense must reasonably perceive a threat to justify the response, and this is how the injury has happened. And there cannot be, and this was a valid defense against the battery claim. So this is all about the tort against persons, which could be an assault, battery, mayhem, or emotional distress, or malicious prosecution, or deceit and conspiracy. And then there are further few defenses which are available specific to certain of them, some of them. So next is module 5, tort against reputation. So person's tort could be against person, could be physical or mental. Then we only took the element of reputation, and let's talk about that kind of tort. So basically, the civil wrongs that harm an individual's reputation or standing in the society is called the predominantly through defamation or invasion of privacy also. That kind of tort is called tort against reputation. So the standing of the person in the society is nothing but the reputation of the person in the society, how he stands in the society, at what level. And predominantly through, it is done through what? Defamation or invasion of privacy. Either of the way, the person's the tort against the person, against his reputation could be done. So let's pick up the first one, defamation, and let's talk about libel, slander, and freedom of speech and expression in that context. So defamation. We have spoke about defamation in multiple chapters earlier as well, today also. So which is the act of making some false statement about somebody which is not real, and that has caused damage or reputation to that person. It can occur in two primary forms, libel and slander. Now, the loss of reputation in the defamation has to be reasonable. It cannot happen that I come back and say, I believe ABC is a ghost. It cannot be. But if I come back and say, so and so person, I go to the employer and go to the society and say, this person seems to be a drug addict. That's a serious defamation of the person's reputation standing in the society. So what does libel means? So libel means a defamatory statement that are made in a fixed medium, primarily written or published form. So it is fixed. Book, article, social media post. These are libelous statement and are considered permanently detrimental since they are documented. It's a document which is created. While slander is defamatory statements that are made verbally and are not recorded in a fixed format. Damages from slander can be hard to prove since it is transient and often requires evidence of harm or damage. But this is not so a case nowadays. We have CCTV, we have mobile cameras, etc. So let's first go back to the defamation, that in the civil laws, defamation typically leads to claim for damages. And the harmed individual, primarily the plaintiff, can seek a monetary relief compensation for the damages to their reputation caused by the false statement. For example, a newspaper publishes an article alleging a local politician who is engaged in criminal activity and damaging their reputation. The politician may sue the newspaper for damages based on defamation. While the criminal perspective of defamation is that some jurisdictions may prosecute defamation as a criminal offense, particularly if the statement were made with malicious intent. So, criminal defamation aims to deter individual from making false statements. So, deterrence is the element of criminal law perspective. For example, malicious individual makes false claim about another person's character in a publicly aired statement that leads to public outrage and unrest. People have gone ahead and they have broken his window, car window, house window, thrown stone at the person, and there is an unrest, an outrage. In this case, the individual could face criminal charges for defamation. So, defamation has a civil perspective and the criminal perspective, but we talk here about more of the civil perspective. So, libel and slander. Let's take a case example. Rafi brothers versus Corina. Rafi, Roffey brothers versus Corina, Corina. Rafi brothers versus Corina, 1987. So, a newspaper published false information regarding a contractor's business practices and called him somebody who follows a malpractice. So, the court, when the matter went there, found that the published statements were written, it's a libel, and had caused quantifiable damage to the contractor's reputation, because if it goes to the newspaper, nobody will come to that contractor for the business further. So, contractor was awarded damages for the harm inflicted by the libelous statement. In case of slander, the case law is Humpid versus Owen, Humpidge, Humpage versus Owen, 1992. A person made a false verbal statement regarding another individual's integrity in a social gathering. So he talked about loosely about his integrity. The plaintiff could demonstrate that the remarks led to reputational damage. He was able to prove that. And the jury found that in favor of plaintiff based on the harmful impact of the slanderous remark. So it's a slander which was proved. And how you could prove slander? Either via video recording or via the witnesses who might have witnessed, who might have seen that. So under defamation, nowadays we do have something called cyber defamation. Defamation in cyberspace. So when a defamatory statement is made online, for instance, through a social media like Facebook, blog, WhatsApp, website, given the vast dissemination capacity, it can go to any place very fast to a number of people on the internet, and the potential for rapid spread because of that, a cyber defamation has become increasingly significant. For example, a false statement about an individual that goes viral on social media, damaging their personal and professional reputation. That is a case of a cyber defamation. Case law is Dendrite International, Dendrite, Dendrite International, Inc. versus DOE number 3, DOE number 3, 2001. In this matter, an anonymous individual posted defamatory statement on an online forum. He was anonymous individual, leading the plaintiff to seek the identity of the author. The court ruled that the plaintiff must provide evidence of the defamation. What are the defamatory nature of the statement and the damaging impacts for the pony of the identity to be enforced. So the extraction of the identity. Now the plaintiff was allowed to proceed with identification, emphasizing the accountability of the online speech. So online speech was done by somebody who did not reveal his identity. Now the person who got damaged severely because of this defamatory statement made for no reason and a false reason, false, falsely. So the person went ahead to the court and did a uh, filed a petition to reveal the identity of the person through the social media portal where it was posted. So the court first says in case of this cyber defamation, which is nothing but a defamation. So it follows the basic rules of the defamation. So you need to come back and first let us know how this defamation, we understand this could be a defamation, could be, but it could only be a defamation if the harm is happened. Once something which is circulated is completely wrong. So that was something which is the plaintiff had to prove in the court. Once the plaintiff was able to prove that point, the court then allowed the portal, uh, passed an order that the portal should reveal the identity of the person so that he could be punished. What could be the defense of a defamation? As I said earlier, just now in the previous module, truth. You can come back and say what is called causing defamation is not defamation. It's a fact which I have told. So it is absolutely true. And it's an absolute defense against defamation. Because now the burden lies with the, of course, the burden lies with the defendant to prove the truth of the statement. But if he is able to prove that it was a truth, then there is no defamation. There can't be a defamation claim for speaking truth about somebody. So against defamation claims are essential uh, defense is the truth, and that's what we understand in the case law. Mason versus New Yorker magazine INC. Mason MASS1 Mason versus New Yorker magazine INC 1991. So the magazine published statements which attributed to a writer that he claimed his claims were false. So certain claims were false. That's what the magazine published. The court established that the truthful statement, even if damaging, cannot be considered defamatory. So the defense of truth was upheld and dismissing the defamation claim. So when the newspaper has published something which was pinching to the other party, which might have against his reputation, but it was just a revelation of a fact and which cannot be considered a defamation. So that is why the primary defense to defamation is calling it a truth. So it is also known as a another defense could be fair comment, which is allowed to particularly journalists and commentators, the people who make those, to express opinion on materials of matters of public interest, provided these options are based on true facts and are not made with malicious intent. So any public interest thing, if you go ahead and speak, which is not because of any malicious intention, but just for the sake of doing that in the interest matters of public interest and with the true facts. Case law, Rosenblatt versus Baer. So Rosenblatt is one word. So ROSENBLATT. Rosenblatt versus Baer. BEAR. Baer. 1966. A public figure sued for defamation over a review that characterized him negatively due to alleged mismanagement of a public theater. So it was published by an article in a journalist which reviewed his character being a negative person due to because he has done some mismanagement of a public theater earlier. So this person brings a suit against this person to sue him for defamation. So the court ruled that the comments made were opinion He did not make a judgment. He just made an opinion based on some other relevant facts on a matter of public interest, which was his job also as a journalist, and based on factual circumstances. It might be circumstantial, but it was an opinion. It was not a judgment about somebody, and it qualifies as a fair comment. So this is also one of the very strong defense are against the defamation. So in this case, the court upheld the fair comment defense, reinforcing that opinion about public figure are protected, provided they are not malicious. Then privilege is another defense, where somebody is privileged to talk about something or someone which is absolute statement which are made, and the person is privileged to make those statements or qualified to make those statements. For example, situation where a statement is made and are protected by privilege, for example, in a judicial proceeding, in the court by the advocate or the judge. So these are qualified as privilege. They can come back and question that person. For example, in across, somebody can come back and say, you have done so and so, which we have heard about it, and you seem to be somebody who is very much fond of having so and so bad habit. So it's not a defamation of that person. It's a privileged communication which is happening in the court of law, in the proceedings of the judiciary proceeding. So it's a privileged communication. Nobody could be attributed to a defamation if done so. Then consent. If the person to whom the statement release consented to the communication of that statement, they may not later claim defamation. So if I publish something about you and I come back and take a signature from you saying this is what I'm going to publish, you said yes. I don't change a word and I publish that, and tomorrow you realize in the morning when you were sane and uh, free from the alcohol in the evening, and then you come back and say, boss, this is wrong. You have done a defamation. Sorry. You have signed on it. You have agreed to it, and I had no understanding of your mental status at that point of time. I came to the office the time you called me for the purpose. You put a seal and sign on that, and you agreed to that. You cannot call it a defamation later. So that is, there are three primary defenses for defamation which could be taken. Is one is truth, which is the first one, a fair comment which could be done in public interest and as mostly for the journalists, and the privilege communication, which is in terms of the court matters or a police officer during investigation, etc. And a consent, if you've already consented to something, you cannot come back and call it defamatory later. The last topic is invasion of privacy and defenses is also something which is a tort against reputation. Of course, invasion of privacy has become far more important nowadays because of the social presence. So by the name it says, the invasion of privacy refers to unauthorized intrusion into individuals' private life, causing emotional distress or harm, sometimes social and reputational damages also. And this tort protects the personal information and the right to privacy from unlawful disclosure or interference. Nobody can come back and use the unauthorized intrusion into somebody's private place, private place or private space, private life. Take some examples. An unauthorized publication of intimate photograph of an individual without their consent, leading to emotional distress. Somebody clicks some intimate moment picture of somebody in a party and then puts in their own Facebook or whatever, um, Instagram, etc., etc., and this caused uh, a invasion of privacy uh, done by the other person, and this caused emotional distress because probably that was not something they wanted to reveal to the world at that point of time. surveillance or monitoring of an individual's private activities without consent, causing emotional harm or other kinds of harm. For example, fitting a secret camera in a hotel room or in some hostels, we come to know about those things. So that is also surveillance on monitoring of an individual's private activities without consent. Even if you go ahead and you follow somebody every day in a distance and note down what time they come go there and what time she goes there and where what time she comes back from college, where she goes, whom she meets, that is also a individual's monitoring of individual's private life, and that is also which comes under invasion of privacy. You are not allowed to do that. So the famous case law is Kelly versus the United States. Kelley, Kelly versus the United States, 2014. So a government agency leaked sensitive personal information of a public officer by mistake. So their personal information of one of the government agency, they leaked for that one of the public official. They were holding it, they released it by mistake. So the court examined the circumstances surrounding the data breach and when the proper consent was obtained for the sharing. Was it actually taken a consent before they do it? So the court found in favor of the plaintiff that the unauthorized release of the private information happened and it's an invasion of the privacy, and he was compensated for that. Of course, these are universal laws, but at times these are also governed by the policy of the state as well. So invasion of privacy, quantifying it up to what level is depending upon also the laws of that state. When I say state, it means a country. So for that particular state, it is depending upon how they define it also. For example, if you go to certain countries, they in the Asia only, they have a very extensive network of cameras which would continuously capture your everyday movement and put it in a database. So there it is not a concern because that is the legal makeup of that country. Now, next case law is Soker versus MySpace Inc. Soecker, Soker versus MySpace, one word, Inc. 2009. A parent sued for invasion of privacy after discovering that MySpace allowed strangers to view her child's profile, which was a cause of distress to them. And the court evaluated the extent of the website's control over users' privacy setting. And although the claim was dismissed, the case highlighted ongoing concerns about privacy right in the digital age. There was a recent case also where a lady had stored certain documents in the Apple Drive, and that particular file was somehow released to the public. And that's where she won a heavy legal suit against Apple Corporation also for accessing her data, which was marked private and letting it available in general. So there are many such flavors and forms of privacy related concerns nowadays. And in digital era, it has become far more dangerous because it might happen because some hacker, some malicious application, etc., can do that without your consent. But again, the defense for invasion of property is also privacy is also the same things which causes the harm. So first is consent. If somebody is doing it with a consent, individual consented to the action which has led to the alleged invasion, this serves as an effective defense. For example, you come back and you do a setting, for example, MySpace matter, which was dismissed because of the same thing. You file an app, you install an application, and that application is there to give you some other activity support, which is no relation with access to your photo folder. While installing it, asks you, can the application have full access to your photographic folder? You go back and say yes, and tomorrow that is used, it is not an unauthorized access. You allowed it. If you go back and allow to minimal use and you put some particular folders mark and that goes from beyond that folder, then it is a crime. So that consent is sometime not known also when you do in the digital area era. Now, news worthiness and public interest. This is also a defense. So, if the information disclosed pertains to a matter of public interest or newsworthiness, it might not constitute an invasion of privacy. For example, a very famous, it's an hypothetical situation, don't put your mind on that. A very famous actor or actress, you go and invade his or her private life by putting a camera near their house, inside the house, and clicking some pictures and putting on the website, you're gone. A lawsuit will be filed against the privacy invasion and you will certainly lose it and you will have to pay a heavy compensation. But tomorrow you see the same person eating something which is not allowed. For example, the person you see eating a corpse, eating monkeys, eating something which is not right, not allowed by law, which is not moral, or doing something which is immoral, and you click a picture and then you go back and give it to the law enforcement, or you publish, you are a journalist, publish in the newspaper, sensational, this person eats human, then it is not a privacy invasion. Privacy invasion only because it cannot, it's beyond that person's personal sphere. It is impacting the social sphere. So that is where the privacy is limited to the being private information, which could on lost will be even not a harm, then call you a displeasure because you did not wanted to release that picture. So that is something which is part of privacy and defense. So cyber defamation is also one topic which I'll speak about. So cyber defamation normally involves the publication of false statements about an individual or entity through digital platforms only. So any digital platform, if you're putting, it's a cyber defamation. So this is a new term in the new world where a specific defamation, which is cyber defamation, happens. It is something which is at par with libel also because you are publishing something for certain in a fixed medium. Take an example, individual post malum. There are multiple examples, you know that. But taking two examples, individual posts malicious and false comment about a business on social media that led to reputational damage. You had a bad experience with a company, you had a mosquito in your ice cream, and you go back and publish about that particular shop, that so and so ice cream company, they have an outlet. Whenever I go, there is always a bug in my ice cream. It's a malicious and a false, at least it's a false comment. Anonymous defamatory article written about a public figure that spread through online news website without verification. It is also possible for not only for public figure, it could be for any common person also. So famous case laws around this cyber defamation is Bunt versus Tilly. Bunt, Bunt versus Tilly, Tilley, Tilly, 2006. The case involved allegation of defamation after individuals made false statements regarding another person's business practice online. And the court considered the implication of online speech and the requisite standards for publishing defamatory material in digital format in this particular matter. And the rule which the court made was the rule that the publication was actionable, emphasizing that need for diligence and accountability in online content, and it was actually defamatory for the other business. And one business typing about something on social media about another business, they have to be extremely careful again. The reason these could be very dangerous for the other person. Varad, I just saw your message. Please, can you repeat the case law? You tell me at the end. Okay. Now, the next case law is Tute versus Henry. Tuit, Tute versus Henry. 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 This is a matter of 2017. In this case, a blog post, somebody made a blog post that contained defamatory remarks about a professional athlete. So they wrote something about that person. So the court reviewed the standards for identifying online defamation in the context of public figures and the burden of proof for plaintiffs in such scenarios. And finally they found in favor of the plaintiff, reiterating the significance of protecting the reputational rights even in the digital realm. So one cannot think that in out of the millions and millions of pages, if I go ahead in isolation, if I write something in a blog post about somebody, in this case it was a famous athlete, but it could be anybody. If somebody tomorrow posts about one of you something which is completely defamatory against you, and with a picture or without picture, with a name and with full detail identifying you, why we call always about the celebrities? Because they are easily identified by simply by name or by photograph. Somebody comes back and says Saif Ali Khan, Salman Khan, you will automatically understand. Your mind will have the picture and understand. But somebody right now says Varat Patil. Tomorrow Varat will become a very famous person, but at this point of time, somebody says Varat Patil, they will not understand. So if they come back and say Varat Patil, studying in DY Patil, son of so and so person, address this and this is the picture, and this person does this. A heavy defamation against you, and you can go ahead and sue. You need not to be Salman Khan or Saif Ali Khan for that. So the court found it's favorable again towards the plaintiff, and the defendants were supposed to pay for the compensation. So there are summary of defenses which are available, uh, which we discussed today in all the cases in module 5. One was the truth, which is a robust defense against defamation; fair comment, which is for a public subject; privileges, which is communication during judicial or legislative or police investigation, etc. Consent, where you consented and you wanted to then go back foot. Public interest, in case of public interest, you saw a celebrity eating a human flesh, you go back and inform with the picture it is not something which is going to impact, or something which is related to public interest, which could cause harm. So examples we have already given, and we talked about the examples of truth, uh, where a newspaper might publish something fact, and if that somebody is aggravated with that and call it a defamation, no, it cannot be. Free and fair comment, we saw that uh, something which is free and fair cannot be somebody's defamation. For example, also, if you tomorrow you go and eat in a restaurant and you find the food at so and so quality, and if you write exactly same without any malicious intent and a reasonable statement that okay, the dal was a little uh, much thicker than it was supposed to be. The chicken was somehow I found it was not very well cooked, and all those things. The company cannot or the restaurant cannot come back and sue for a defamation because it's a fair comment you have made, and it's under within your rights you have done that. And then privileges, like in court and police, we talked about. So conclusion, in when we talk about this reputation loss, primarily it is defamation of various kinds. So the reputation is under the uh, pretext under the four corners of the defamation only. Freedom of speech and expression is a something which is given a right to all of us, but please understand this is not absolute. It is only up to the extent allowable when it is not harming anybody else. It is only for your sake. If you want to freely express and speak about something, which is fine, to bring your perspective, and you are allowed to do that, whether it's a matter of religion, whether a matter of food, your choices. But if it is something which is engaging in terms defaming somebody or bringing some negativity or negative name to somebody, in all those cases, then this becomes a, a cartel is fixed there, and freedom of speech and expression is not ultimate. In those cases, you are again doing a tortious act. Then we talked about causing emotional distress, and we talked about malicious prosecution, abuse of legal proceedings also in the previous one. We talked about deceit and conspiracy in the previous module, and the defenses available, etc., etc. Which case law you wanted to hear again, Varad? Let me stop the recording once first.